Innovation is usually sold to us as a heroic story. A lone inventor, a brilliant idea, a breakthrough that changes the world. But there is another story running quietly in parallel, one that rarely makes headlines and almost never appears in history books. It is a story where ideas are not built, not shared, and not improved. They are owned, locked away, and weaponized. This is the story of the companies that don't create technology, don't manufacture products, and don't serve customers. Their entire business model is built on one thing: lawsuits. And for decades, they have been quietly reshaping the future of innovation from inside courtrooms. For many startups, the first real threat doesn't come from competitors or lack of funding. It comes in the form of an envelope. Inside, there is no feedback, no partnership offer, no interest in collaboration. There is a legal notice. A claim that something they built infringes on a patent they have never heard of, owned by a company they have never met, demanding a settlement that could shut their business down before it even begins. No warning. No negotiation. Just a choice: pay or fight a legal battle that could cost millions. These companies have a name. They are commonly known as patent trolls, though the legal system prefers a softer term: non-practicing entities. The name sounds harmless, almost bureaucratic, but the impact is anything but. A patent troll is an entity that owns patents but does not use them to produce goods or services. They do not innovate in the traditional sense. Instead, they wait. They watch. And when someone else builds something successful, they strike. To understand how this became possible, we need to step back and look at what patents were originally meant to do. In theory, a patent is a social contract. An inventor reveals how something works, and in return, society grants them temporary exclusivity. The goal was to encourage innovation, to reward creativity, and to ensure knowledge would eventually enter the public domain. But over time, that balance shifted. Patents became broader, more abstract, and easier to exploit. What was once a shield for inventors slowly turned into a sword. In the modern tech world, patents often describe ideas so vague they could apply to thousands of products. Concepts like sending data wirelessly, clicking a button to perform an action, or displaying information on a screen. These patents are not tied to a specific implementation or technology. They are ideas in their most abstract form. And when ideas become property, innovation becomes a legal minefield. Patent trolls thrive in this environment. They acquire massive portfolios of these broad patents, often buying them cheaply from bankrupt companies, failed startups, or inventors who never had the resources to commercialize their work. Once acquired, these patents are no longer tools for creation. They become legal leverage. The goal is not to win in court. The goal is to threaten just enough to force a settlement. This is where the math becomes brutal. Defending a patent lawsuit in the United States can cost several $1,000,000, even if the defendant is completely innocent. Most startups do not have that kind of money. Even large companies hesitate. So when a patent troll offers a settlement for a fraction of the legal cost, paying becomes the rational choice. Not because the claim is valid, but because fighting it could destroy the business. And this is the quiet genius of the system. Patent trolls don't need strong cases. They just need expensive courts. Every lawsuit becomes a numbers game. How much will it cost to fight? How much will it cost to settle? Innovation slows not because ideas are bad, but because fear becomes part of the design process. If this already sounds disturbing, it gets worse. Because patent trolls don't operate in isolation. They build networks. Shell companies. Legal mazes designed to obscure ownership and limit liability. One entity sues, another holds the patents, a third collects the money. Even identifying who is behind a lawsuit can be nearly impossible. And this opacity is not accidental. It is strategic. One of the most famous examples of this business model emerged in the early 2000s, when a former tech executive quietly began assembling what would become one of the largest patent portfolios in history. His name was Nathan Myhrvold, former CTO of Microsoft. Brilliant, well-connected, and deeply aware of how intellectual property could be monetized. He founded a company called Intellectual Ventures. Officially, it was framed as an innovation marketplace. A bridge between inventors and industry. Unofficially, it became something else entirely. At its peak, Intellectual Ventures controlled tens of thousands of patents. Some estimates placed the number above 30,000. The company insisted it was not a patent troll. It claimed it helped inventors get paid. But critics saw a different reality. A private patent empire, quietly collecting licensing fees from nearly every major tech company on the planet. Microsoft, Apple, Google, Samsung. Many paid not because they agreed, but because fighting would be worse. This is the moment where the idea of innovation as a battlefield becomes impossible to ignore. When companies spend more money on lawyers than on engineers, something has gone wrong. When inventors fear the patent system more than their competitors, the incentive structure collapses. And yet, for years, this system was not only legal. It was encouraged. Entire regions became hotspots for patent litigation. Courts known for being friendly to patent holders, where cases moved quickly and juries were more likely to side with plaintiffs. Companies were sued there regardless of where they operated. Geography became a weapon. And patent trolls knew exactly where to strike. If you're finding this story unsettling, that's not an accident. Because this system affects more than billion-dollar corporations. It affects the apps on your phone, the services you use, the cost of technology itself. The hidden tax of patent litigation is paid by everyone, whether they realize it or not. And this raises a question that sits at the heart of this documentary. What happens when the system designed to protect innovation becomes the greatest threat to it? When ownership matters more than creation? When the courtroom becomes more powerful than the lab? If you're enjoying this breakdown so far, this is a good moment to pause, leave a comment, and subscribe to the channel. Patent Wars exists to tell the stories that sit between technology, power, and control, the ones that rarely get told clearly or calmly. And in the next part, we're going deeper into how patent trolls actually operate, step by step, and why their business model is so effective that even governments struggle to stop it. Because once you understand the rules of this game, you start seeing them everywhere. To understand why patent trolls are so effective, you need to stop thinking of them as legal anomalies and start seeing them for what they really are, highly optimized businesses. Their product is not technology. Their service is not innovation. Their revenue comes from fear, uncertainty, and the staggering cost of the legal system itself. And once you see the structure clearly, it becomes obvious why this model spread so fast and why it has been so difficult to dismantle. At the center of this business is asymmetry. Patent trolls design every step of their operation to minimize their own risk while maximizing pressure on their targets. They rarely sue directly under a single, visible corporate name. Instead, they create dozens, sometimes hundreds, of shell companies. Each one holds a small set of patents. Each one exists for a single purpose, to file lawsuits. If one case fails, the damage is contained. The larger network remains untouched. This fragmentation is not just clever. It is essential. These shell companies often have no employees, no offices, and no public-facing presence. On paper, they look insignificant. In practice, they are legal landmines. When a lawsuit is filed, the defendant often struggles to even identify who is behind it. Discovery becomes slow and expensive. Accountability becomes abstract. And all the while, the clock is ticking, and legal fees are piling up. The patents themselves are carefully chosen. Trolls are not interested in complex, narrow inventions that are hard to apply. They want patents that are broad, ambiguous, and difficult to disprove. A patent that claims ownership over sending information to a remote device or displaying content based on user input can be interpreted in countless ways. The vaguer the language, the more powerful the threat. In this system, precision is a weakness. Ambiguity is a weapon. Once a patent is acquired, the waiting begins. Trolls monitor industries, product launches, and market trends. They look for success, not experimentation. A startup that fails is useless to them. A company that gains traction, attracts users, or raises funding becomes a target. Success is the signal. Innovation is not punished at birth. It is punished at scale. When the moment is right, the first contact is rarely dramatic. It often arrives as a polite letter. A notice of potential infringement. The language is calm, professional, almost friendly. It offers a chance to resolve the issue quietly. No accusations. No courtroom threats. Just a suggestion that a license might be required. This is not generosity. It is strategy. The goal of this initial contact is psychological. It forces the company to consult lawyers. To pause development. To question past decisions. And once lawyers are involved, reality sets in quickly. Even reviewing the claim costs money. Investigating the patent history costs money. Responding formally costs money. Before a lawsuit is ever filed, the financial pressure has already begun. If the company resists, the tone changes. A formal lawsuit follows. And this is where the true imbalance becomes unavoidable. Patent litigation is slow, technical, and brutally expensive. It can take years. It can consume entire legal teams. And it can distract leadership from running the business. For a startup, this can be fatal. For a large company, it is still painful. Patent trolls understand this perfectly. They do not aim to prove infringement beyond all doubt. They aim to make the process unbearable. Their settlement offers are calibrated carefully. High enough to be profitable. Low enough to seem reasonable compared to the alternative. This is not negotiation in the traditional sense. It is controlled extortion, operating within the boundaries of the law. And because the system allows it, this strategy scales. One patent can generate dozens, sometimes hundreds, of settlements. Each one small enough to avoid headlines. Each one large enough to justify the next lawsuit. Over time, a single vague patent can become a revenue stream worth tens of millions of dollars. Not through invention, but through repetition. This model also benefits from a legal doctrine known as the presumption of validity. Once a patent is granted, courts assume it is valid unless proven otherwise. Challenging a patent requires time, expertise, and money. And even then, success is not guaranteed. The burden of proof lies with the defendant. The troll simply needs to exist and wait. The result is a chilling effect that is difficult to measure but impossible to ignore. Engineers start designing products not just around technical constraints, but around legal risk. Features are removed. Ideas are delayed. Entire areas of innovation become too dangerous to explore. This is not because the ideas are bad, but because the legal shadow around them is too large. Some defenders of the system argue that this is simply the cost of protecting intellectual property. That without strong enforcement, inventors would be exploited. But this argument collapses under scrutiny. Patent trolls do not protect inventors. They rarely share profits with original creators in any meaningful way. They protect portfolios. They protect leverage. And they profit from a system that rewards ownership over contribution. What makes this even more troubling is how invisible it all is. Most settlements include non-disclosure agreements. Companies are legally prevented from talking about what happened. There are no press releases. No public trials. Just silence. And silence is fertile ground for repetition. By the time regulators began paying attention, the model was already entrenched. Patent litigation had become an industry. Lawyers specialized in it. Courts were accustomed to it. Financial institutions factored it into risk assessments. The cost of innovation quietly increased, line by line, lawsuit by lawsuit. And yet, for all its sophistication, this system depends on one fragile assumption, that most companies cannot afford to fight back. In the next part, we're going to look at the moments when that assumption failed. The cases that exposed the mechanics of patent trolling to the public, the industries that were hit hardest, and the rare instances where defendants pushed back hard enough to force change. If this story is changing the way you think about technology and innovation, this is another good moment to support the channel with a like or a comment. These stories matter because they shape the tools we all rely on, whether we see them or not. And in the next part, we're moving from theory to reality, diving into real-world cases where patent trolls collided with startups, hospitals, cafés, and entire industries that never saw it coming. Patent trolling stops being an abstract legal problem the moment it collides with the real world. Away from boardrooms and court filings, its impact shows up in places that were never meant to become legal battlegrounds. Small offices. Coffee shops. Hospitals. Classrooms. Spaces built for people, suddenly forced to defend themselves against ideas they didn't even know were owned. And it is in these cases that the true cost of the system becomes impossible to ignore. One of the most infamous waves of patent trolling targeted something almost invisible, Wi-Fi. For most people, wireless internet feels like infrastructure, not innovation. It is just there. But for patent trolls, it was a goldmine. Companies were sued simply for offering Wi-Fi to customers. Hotels, cafés, restaurants, and small businesses received legal threats claiming that providing wireless access infringed on patents related to networking technologies. These businesses had not built routers. They had not designed protocols. They had simply plugged in equipment bought from legitimate manufacturers. And yet, they were told to pay. The logic was surreal but legally viable. If a business used technology that allegedly infringed a patent, it could be held responsible, even if it had no control over how that technology worked. The message was clear. Participation alone could make you a target. And for many small business owners, the choice was brutal. Fight a lawsuit you don't understand, or pay a settlement you can barely afford. Most paid. Not because they were guilty, but because they were trapped. The tech startup world faced an even harsher reality. Mobile apps, in particular, became prime targets. Patent trolls began asserting ownership over basic software interactions. Swiping gestures. In-app notifications. Content recommendations. Features so fundamental that avoiding them would make a product unusable. Startups were sued before they reached profitability, sometimes before they even launched publicly. The lawsuits did not question quality or originality. They questioned existence. In some cases, a single troll would sue dozens of startups at once, using the same patent. Each case isolated. Each defendant too small to mount a serious defense. There was no incentive to coordinate. No shared legal front. The system encouraged fragmentation, not resistance. And one by one, companies folded, paid, or disappeared. Perhaps the most disturbing examples emerged in healthcare. Hospitals and medical providers found themselves sued for using everyday technologies. Digital record systems. Imaging software. Even basic communication tools. In one widely criticized case, a patent troll sued hospitals for scanning documents and sending them via email. The technology in question was not experimental. It was essential. It was used to save time, reduce errors, and improve patient care. And yet, it became a liability. The ethical contradiction was stark. Lives were being saved using systems that had become legally radioactive. Doctors and administrators were forced to divert resources away from care and into legal defense. And once again, most cases ended quietly, behind closed doors, settled out of court, erased from public discussion. Even schools were not immune. Educational institutions faced lawsuits over online learning tools and digital communication platforms. The irony was painful. Technologies meant to expand access to education were being monetized through legal pressure. Innovation in learning was slowed not by lack of imagination, but by fear of litigation. Large corporations, with their vast legal teams, were better equipped to fight back. But even they were not invulnerable. Many chose to pay licensing fees simply to avoid disruption. For them, it was a cost of doing business. For everyone else, it was an existential threat. This imbalance is what allowed patent trolls to thrive across industries, not just in technology, but anywhere ideas could be described, abstracted, and claimed. Public awareness began to grow as journalists and researchers started connecting the dots. Patterns emerged. The same patents. The same law firms. The same jurisdictions. Entire litigation ecosystems were identified, operating with remarkable consistency. What once looked like isolated disputes began to resemble an assembly line. One of the most controversial aspects of these cases was how little innovation was actually involved. In many lawsuits, the patents predated the accused products by years or even decades, yet had never been implemented in any meaningful way. The ideas existed only on paper. Their value came not from use, but from timing. When the world finally caught up technologically, the lawsuits began. This raises a deeply uncomfortable question. Should someone be allowed to claim ownership over an idea they never turned into reality, simply because they described it first? And if so, for how long? The patent system was never designed to reward speculation. Yet in practice, that is exactly what it has done. As backlash grew, lawmakers and courts were forced to respond. High-profile cases drew attention. Judges began scrutinizing vague patents more aggressively. Some lawsuits were dismissed. Some patents were invalidated. But progress was slow, and the damage was already done. Entire generations of startups had grown up in a climate of legal anxiety. For many innovators, the lesson was clear. Innovation alone was not enough. Legal strategy had to be part of the business model from day one. Patents were no longer just protection. They were shields, bargaining chips, and sometimes ransom notes waiting to be written. If this pattern feels unsettling, it should. Because it reveals a system where success invites punishment and creation invites scrutiny. And in the final parts of this documentary, we're going to examine what happens when the system is pushed too far. When governments intervene. When courts push back. And when the future of innovation itself is forced into question. If this documentary is giving you a clearer picture of how innovation really works behind the scenes, take a moment to support the channel. A simple like or comment helps these stories reach people who have never heard them before. And in the next part, we'll explore the attempts to reform this system, why many of them failed, and how patent trolls adapted instead of disappearing. By the early 2010s, it became impossible to ignore what was happening. Patent litigation was no longer a niche legal issue confined to tech giants and specialized courts. It was affecting small businesses, hospitals, schools, and entire sectors of the economy. Innovation was slowing in subtle but measurable ways. Startups were budgeting for lawsuits before hiring engineers. And governments, finally, were forced to acknowledge that something in the system had gone deeply wrong. The first major attempt to address the problem in the United States came with the America Invents Act. On paper, it promised reform. Faster patent reviews. New mechanisms to challenge weak or overly broad patents. A shift toward a system that favored actual invention over speculative ownership. For a moment, it looked like patent trolls might finally lose their grip. But systems like this rarely collapse all at once. They adapt. One of the most important changes introduced was the ability to challenge patents after they had already been granted, through processes like inter-partes review. This allowed companies to argue that a patent should never have been approved in the first place. In theory, this was a powerful tool. In practice, it was expensive, technical, and still out of reach for many smaller companies. Patent trolls adjusted quickly, focusing on portfolios that were just strong enough to survive these challenges, or spreading risk across even more shell entities. Courts also began to play a role. A series of landmark decisions narrowed what kinds of ideas could be patented, especially in software. Abstract concepts, the courts argued, should not be owned. A patent needed to describe a concrete technological improvement, not just a goal achieved through generic computing. These rulings invalidated thousands of patents overnight. For innovators, it felt like a turning point. For patent trolls, it was simply a signal to evolve. Instead of relying solely on abstract software patents, many shifted their focus to hardware-adjacent claims, networking technologies, and industry-specific processes. Others moved their operations internationally, exploiting differences between patent systems. Some stopped suing directly and began operating through licensing demands, staying just below the threshold that would trigger major legal scrutiny. Another unintended consequence of reform was consolidation. As weaker patents were struck down, the remaining ones became more valuable. Large patent-holding entities doubled down, acquiring higher-quality portfolios and using them more strategically. The business didn't disappear. It became more refined, more selective, and in some ways, more dangerous. Meanwhile, defensive strategies emerged. Tech companies began forming alliances, sharing patents to create legal shields. Defensive patent pools were created, allowing members to use each other's intellectual property without fear of litigation. Some companies pledged not to assert patents offensively, framing intellectual property as a tool for protection rather than profit. These efforts helped, but they were voluntary. Patent trolls, by definition, were never going to join. Governments experimented with fee-shifting rules, attempting to make losing plaintiffs pay defendants' legal costs. The idea was simple: discourage frivolous lawsuits by increasing risk. But once again, trolls found ways around it. Shell companies with no assets could lose cases without consequence. The real owners remained insulated. Risk was externalized. Pressure remained intact. What became increasingly clear was that the problem was not a single loophole or bad law. It was structural. The patent system had been stretched far beyond its original purpose. In a world where innovation moves faster than legislation, ownership claims lag behind reality. And those gaps are where exploitation thrives. For inventors, the emotional toll was just as significant as the financial one. Many described feeling betrayed by a system they believed existed to protect them. The promise of patents as a reward for creativity had been replaced by a fear of accidental infringement. Innovation began to feel less like exploration and more like navigation through a legal maze. And yet, despite all this, patent trolls did not become villains in the public imagination. They remained largely invisible. Their work happened quietly, legally, and out of sight. There were no viral scandals. No dramatic collapses. Just a steady background hum of litigation shaping the boundaries of what could be built. By the end of the decade, the conversation had shifted. The question was no longer whether patent trolls existed, but whether the system could ever fully escape them. Reform had helped, but it had not solved the problem. The incentives remained misaligned. Ownership was still more valuable than contribution. And fear was still cheaper than justice. In the final part of this documentary, we're going to step back and ask the hardest questions of all. What does innovation look like in a world governed by legal threats? Who really benefits from this system? And if patents are meant to protect the future, why do they so often feel like they're holding it hostage? If you've stayed with this story so far, this is a great moment to subscribe to the channel and join the conversation. Patent Wars is about understanding the hidden forces that shape technology long before it reaches our hands. And in the next part, we're closing this chapter by looking at the future of innovation itself, and whether it can ever truly be free from the shadow of the courtroom. By now, one uncomfortable truth should be clear. Patent trolls are not a glitch in the system. They are a predictable outcome of it. They exist because the rules allow them to exist, because the incentives reward them, and because fear has proven to be more profitable than creation. As long as ideas can be owned in abstract form, and as long as defending innovation remains more expensive than attacking it, this model will survive. For innovators, this reality quietly reshapes behavior. Engineers learn to think like lawyers. Product managers ask not only what can be built, but what can be defended. Entire features are abandoned not because they are flawed, but because they are legally risky. In this environment, innovation becomes cautious, incremental, and defensive. The bold ideas, the ones that challenge existing systems, become liabilities before they become breakthroughs. This has long-term consequences that are difficult to measure but impossible to ignore. Fewer startups take risks. Investors factor legal exposure into funding decisions. Markets consolidate, favoring companies large enough to absorb litigation costs. The very structure of innovation changes, drifting away from open experimentation and toward controlled, permission-based progress. This is not how technological revolutions are supposed to happen. Some argue that this is simply the price of maturity, that early innovation is chaotic and that legal frameworks bring order. But history suggests otherwise. The most transformative periods of technological growth were defined by openness, competition, and rapid iteration. When fear enters the equation, creativity narrows. And when creativity narrows, progress slows. There is also a deeper philosophical question at the heart of this story. Can an idea exist independently of its implementation? Should the act of describing a possibility grant ownership over its future? Patent trolls bet everything on the answer being yes. Innovators, by building, argue the opposite. That ideas gain value through execution, refinement, and real-world impact. This conflict is not just legal. It is cultural. Looking forward, new technologies threaten to repeat the cycle. Artificial intelligence, machine learning, biotechnology, and quantum computing are already generating vast numbers of patents, many of them broad, abstract, and speculative. The risk is obvious. If the lessons of the past are ignored, the next generation of innovation may be shaped less by inventors and more by litigators. And yet, there are reasons for cautious optimism. Awareness matters. Courts are more skeptical than they once were. Policymakers are paying closer attention. Engineers are more informed about intellectual property risks. The conversation has shifted from blind trust in the system to critical examination. That shift alone changes the landscape. But reform will never be simple. Any system powerful enough to protect inventors is also powerful enough to be abused. The challenge is not to eliminate patents, but to realign them with their original purpose. To reward creation without enabling exploitation. To protect innovation without suffocating it. Ultimately, the story of patent trolls forces us to confront an uncomfortable reality. Innovation does not exist in a vacuum. It exists within systems of power, law, and economics. And those systems shape not only what gets built, but what never does. The inventions we never see, the ideas abandoned before they could grow, are the hidden casualties of this war. Patent wars is not just about the past. It is about the future we are choosing, often without realizing it. A future where ideas can be nurtured, shared, and improved, or one where they are stockpiled, monetized, and used as weapons. The difference lies not in technology itself, but in the rules we build around it. If this documentary changed the way you think about innovation, power, or ownership, consider leaving a comment with your perspective. Conversations like this matter, because they shape awareness long before laws catch up. And if you want to keep exploring the hidden battles behind the technologies we use every day, make sure to like the video and subscribe to the channel. Because the next war over innovation is already being fought. And this time, it's happening before the future even arrives.